All right, so this is the second workshop for administrative law. Good that I know what subject I'm teaching tonight. And the objective of the workshop for week 2, there's a couple of things. One is to make sure everyone is feeling confident with the different structures of the system, with the different various moving parts of the system. And admin law, I think one of the reasons why it can be a little tricky for some people to get their head around is that it isn't a body of law like, say, criminal law is or family law is. It's a series of different interlinking systems. And once you get a handle on those and you know what they are and they work together, it's fine. But if you're used to the sort of law subject where it's like, here is the legislation, here are the cases, just go and apply it. There's a little bit of that in admin law, but it's really about a combination of things. So part of it's about seeking remedies using the legal system, but it's also about all these other systems that impact on each other. So I want to make sure people are pretty confident with the distinctions between those before we go much further. And the other part of tonight's workshop is to give people a chance to, now you've had a week to look at the basic materials, to have a look at the assessment and so on, to ask questions. Because I think sometimes we launch too fast into subjects and people don't necessarily have time to look at those things and to make sure they know what they're doing before they go too much further. So it won't take us the whole hour to talk about, to do the workshop question tonight. Others will be longer than this, but bear in mind that if there's things you want to talk about, this is a really good opportunity to do that. And I deliberately didn't jam-pack week 2 for that reason. I always found it a bit confounding when people sort of launch into week 1 and you go straight into substantive law, and you don't sort of get a chance to ask some of those questions. So yes, I will be asking later. So if there's burning issues that you need to discuss, good opportunity. All right. Okay, so hopefully you guys have managed to get a copy of the textbook by now. The readings this week are really about the foundation ideas of admin law. I push this a lot in this subject because I know when I studied admin law, I managed to get through of it without ever really understanding what admin law was. And it has this reputation for being this sort of arcane area of law, which it doesn't deserve at all. It's often just because the way it's taught and the way some of the older textbooks are. So I really want to make sure everyone has a chance to think about and discuss the relationships between our system of democratic government and the legal accountability of that government. Because once you get that, once that stuff starts making sense, the rest of it is a lot easier. And next week we'll look at in more depth in what the foundation principles of admin law are. And again, if you understand where they're coming from, you'll understand something like procedural fairness or Alrighty. Okay, so there's a couple of readings this week. One is just generally on the admin law system, and the other is on the public-private divide. And this is becoming more and more important to us because back in the dawn of time when I studied admin law, we had a very certain idea of what public was and what public accountability was. And today we've privatised a lot of things and we're not necessarily all that clear as to what happens then. What happens when we privatise our utilities? What happens when we privatise public transport and we delegate legislative powers to those bodies? And the answer is typically that they have a hybrid character and administrative law continues to apply through them unless there's a reason which they are taken out of the system. But there certainly is an approach from those authorities and those corporations that they still want to act like a private body and they don't want the responsibility that comes with being part of a public system. And that's where admin lawyers come along to remind them that if they're exercising power under legislation, under regulation, they've got that public character and they can't just carry on like they're running a shop. Alrighty, so I don't want to go into any of that stuff in particular depth. What I'll do is I'll just quickly show you. I don't know if you guys have seen Coggle, and it's a very simple mind mapping service that's, first of all, it uses your Google login, so you don't have to sign up to a whole set of new things for it. And second of all, it's cloud-based, so you can actually share mind maps. This is a really, really useful tool when designing things in a team. And I'll show you a little bit of that tonight. There's also MindMeister, which I've sent you the links for, but I haven't had time to look at it in depth. And it's a more comprehensive system that Stephen found, I think, last week or the week before last. So I want to spend some time with that before I push it and see how it works. But mind mapping is really useful for lots of reasons, and in study, it allows you to learn in a different way and to use different neural pathways to learn. So rather than just writing down a lot of facts, if you're actually positioning things relationally, visually to each other, you learn things a lot faster. So there is a mind science behind it all. It's not just it's not all spurious. So if I share my screen and go into Firefox. Oh, there's new options in sharing screen. There's remote control and all kinds of things. Wow. Okay, Zoom's had an upgrade at some point. All right. It's coggle.it, which I suspect they're not from Italy. It's just sort of Coggle it is the URL. But you get into that, and I've already logged in, obviously. So you use your Google account, logs you in, sets you up, and it just opens with a screen like this. So if I click on Edit Title there, I can that's what I meant to say was Administrative Law Systems. As I said, it's a free service too, and it's very, very simple. And you can even add images and things to that. But it creates a block, and then you can create extra blocks off of each of these. So if I want to create something over here and talk about legal review of decisions, it's not only created that as a block that you can type into, but you can also create extra links off of that block. So I hit plus there, and you'll see that review of decisions now has another limb that comes off there, and I can type judicial review. And if I want to create another branch, I can go back here and press plus, and it'll create another one, and I can call it merits review. And one of the nice features of this is that these things become drag and droppable as you go, and you can start moving things around as you start adding extra elements. And one of the things you find when you're mind mapping is you think you've got a nice plan of how everything goes, and you've got it nice and balanced, and all of a sudden you realise there's 100 things down in this section down the bottom, and there's nothing over this side, and you have to adjust. Now, from what I can see, MindMeister is actually going to be is going to look a lot nicer by the time you're finished. But this is simple and intuitive. And as I said, I think this works for any area. You know, I would have thought doing one of these for torts would have been really useful. I think any area of law, but particularly ones where you've got subcategories and subcategories, it's really quite useful. Now, What I'm not sure is if I can view the chat window while sharing the screen. There's an interesting conundrum. Look at those options. The other thing that was hidden for me by the Zoom window is up the top here. There's a link that says share this coggle, and I've managed to hide it again. You can create a link there which you can send to others, and other people can then interact live with this mind map. So what I will do, if you want to have a go at this, I mean, it's nothing much here to break, so it's worth having a go. So if I copy that link and I figure out how to get back to the chat window, which might mean stopping sharing for the moment. Again, there's a comment from Jamie saying MindMeister gives you very basic access and you can upgrade to get more customization. Yes, so I'll have a look at that. Okay, so if I hit that coggle link there, and if you have a go on that link, fingers crossed, it should give you right access to it.
Sorry, Scott. It's Jamie here.
Yeah.
I just clicked on the link. It takes you to it, but I don't think it gives you the option to see it.
Yeah. Okay. This is the thing with cloud-based apps, is that they change the functions all the time, and I'm just going through to see if there is a new link. You can share it with those who are logged in, but people can see it. Yeah, they seem to have taken away the interactive component of that. Okay, so my recommendation of Coggle is not as, that's a function that has now disappeared. Okay, I'm just going to quickly Google Coggle share edit to see. See if there's a comment on if there's something really obvious I'm missing. No. Okay, I won't waste our time talking about that. I might just jump back to share screen. So yeah, Coggle used to, and this is why I liked it, it used to allow multiple people to get in like a Google Doc and access it and change things and move things around. And that was really cool because you could actually edit things live and watch other people moving things around. I don't know whether they've found that was costing them too much money to allow people to do that for free or whatever, but it doesn't seem to have that option there anymore. What a shame. But the point is, I guess, if you just want this as a simple thing for you to work on for yourself, and you want to show it to other people, but obviously not let them edit it, it's it's a really, really easy tool for doing mind mapping. And I've seen some others, and as I said, I haven't looked at MindMeister, but I've seen some others that you need to sort of read the manual before you start working with them, and no one really wants to do that. And Jamie's just pointed out that it has paid plans, which is probably what they've done by taking that function out, is trying to sell the paid one. And I will investigate that later and see what happens. But for the purposes of the exercise, doesn't invalidate that at all. So let's just jump back to sharing screen on it. Unfortunately, I don't have the chat window open here, but if you could give us a hoy at other things that we should add to this, and I'll just type them in. and you know, we'll do it the slightly old-fashioned way. What else do you think we should add to this map? Just give me a yell. And
hello, tribunals, maybe? Tribunals?
Yeah, so the tribunals are, I guess, a form of merits review. And we could actually add to that, and we could put the AAT, and we could put the state tribunals there. This is not supposed to be an exemplar for how this plan should look at the end of the day, by the way, because I'm not going about this in a very methodical way. Is there other forms, and I'm asking this, and it's not in the notes, are there other forms of merits review apart from tribunals?
What about ombudsmen?
Sorry, I missed that.
Ombudsman?
Yes. That's not a form of merits review, but let's stick the Ombudsman up here. And we can go down that path a little bit later. In terms of merits review, I wasn't expecting people to think of this because you're just studying this now and it's not really covered. We could also put internal appeals. See, what the tribunals do is form a kind of a one-stop shop for people who want to appeal against decisions by bureaucrats. And one of the innovations of our tribunal system was, in the past, you had to find out who a person's supervisor was and who the decision could be made to, and every single decision was different. So you had to be able to locate the specific pathway to take an appeal. And the advantage of tribunals, particularly when the AAT was invented, was that it was a generic place, a one-stop shop, and you could go, whatever problem you're having with the Commonwealth government, you can put an appeal in, and they'll hear it and they'll review it on the merits. But there still remains those original, in some places, original appeals, where a decision is basically someone makes a decision, and if you don't like it, you can talk to the manager within 7 days and the manager can review the decision. So there still is those internal ones as well. They're kind of piecemeal and they're all over the place and they depend on the organisation, but that is technically also a form of merits review. And what's also happened since the creation of the AAT is the things that are not available for review. There was a list, I think it was like 6 or 7 things in one of the appendices to the original legislation that said, and these are the things that aren't available for merits review. And it was things like internal security, ASIO. It was really kind of significant things like that. And there wasn't many of them. And there are just pages of them now. Over the years, successive governments have said, oh, we don't want review of this, well, we'll just chuck that on the list as well. And that's grown. And that does mean that there are some things that you have to look for alternative appeal options. And this is where the big dream of the tribunals were that judicial review would become a thing of the past because we wouldn't need it anymore. We have a better forum. We are falling back on judicial review quite often now because the government has cut off a lot of the access to those review parts. And in fact, the government has tried to cut off access to judicial review as well. And as we'll see later, the High Court hasn't taken that very well because there's actually a constitutional right to judicial review. And in the situations where the government has tried to do the cheeky thing of saying, oh, we'll just take things out of the ADJR Act, which codifies judicial review, the High Court has turned around and said you can't do that. Well, you can take it out of the Act, but there's still common law rights under the Constitution. So anyway, it's important that we understand, and this is the one distinction that I think troubles students most at the start, is why is there 2 different systems, and why is judicial review different from merits review? And I'm sorry if I'm harping on about this, and you've got it, and you're thinking, why are you still talking about this? But I will still restate it a few times because it can be difficult to get the difference. You know, merits review goes to a tribunal, it's not legal. The review is on the merits, not on the law, and it enables the new decision maker to substitute a new decision. So it's literally like going and seeing someone's boss and getting them to overturn a decision, except that the tribunals are a kind of a generic system that sits there and is everyone's boss in some sort of way. Judicial review is review purely on the legality of a decision. It's has to come under specific areas of law, which are from the common law, and they are codified in the ADJR, the Administrative Decisions Judicial Review Act. And we'll be looking at those in depth next week, or we'll be looking at an overview of those next week, and make sure you've got a copy of the relevant section of the legislation for that exercise, and I've referred to that in the workshop itself, so you'll know where it is. So you can't just, in judicial review, look at a decision and go, look, I don't like that, I'm going to change it. It has to be under one of those heads. And the other thing that lay people find really frustrating is judicial review has no power to make a new decision. All it has the power to do is to invalidate an illegal decision. And there's a couple of other things they can do, like if someone refuses to make a decision, they can force them to make a decision. But mostly what judicial review is about nullifying a decision, and it then reverts back to the decision maker to make the decision properly. And that does, unfortunately, especially considering the legal fees involved with an application for judicial review, can mean that the decision maker can make a decision that has exactly the same consequences, but they just make it the right way this time. So, very basic example, there's a rule against bias, and it's illegal to make a decision when you're a biased decision maker. And someone makes a decision, they're biased for some reason, they might have a conflict of interest. That's an obvious way to show a bias. Goes on to judicial review, it gets invalidated, it gets sent back. They give it to their colleague, who then makes exactly the same decision, but it's not an illegal decision because they don't have that conflict of interest. So judicial review can be very frustrating, and if you know your doctrine of separation of powers, and if you remember constitutional law, and I've put some short document and a video up on Moodle to try and act as a bit of a cue, a bit of revision from constitutional, or things to look for if you haven't finished constitutional yet. But if you know your constitutional law, the judicial head of power and the executive/administrative head of power have to be kept separate. You can't have a court making a ruling and then making a decision that belongs in the administrative field. So that's very technical and very arcane in many ways, but it is an important check and balance on power, because you would have a substantial growth in judicial power if they could start making decisions on behalf of the government. And a lot of the privileges that come and the tenure and the independence that comes with the judiciary is kind of guaranteed by them staying out of politics and staying out of government. And that's one important reason why they can't make those decisions, and why in admin law judicial review is very much hamstrung by the ability to only nullify a decision, not to substitute a new one. And that being said, I don't think judges necessarily want the ability to make new decisions. And sometimes the shaming effect of having a court strike down a decision is enough to get the solution that your client wants in the first place. Sometimes you don't have to force them to make a better decision. Sometimes the fact that there's been public exposure and possibly media exposure to whatever nefarious thing was going on in the government in the first place. And government, remember, is not just politicians, it's everyone down to the dog catchers and the local flunkies and lecturers working at universities and people looking at tickets on trains. All those people are all part of the government, part of the administration. sometimes just the effect of having a court look at a decision and say, you made a bad decision, is enough to get that right, the correct answer in the first, when it gets reheard, because people would be afraid for it to go to court again and to risk it looking like that they're breaking the law again in that way. Does that distinction make sense? Remember, I can't see the chat window at the moment because I'm sharing my screen. So I'll come back to, if you've chucked chat up there, I'll come back to it. But at the moment, I can't see that part of the screen. Okay. So this is the review of decisions part of administrative law. We've also got other limbs of administrative law. Jamie mentioned the Ombudsman before. And this is, I guess, if we wanted to refer to this. Oh, I didn't mean to do that. We're really talking about not the oversith. It'll be something else entirely different. We're talking about the oversight of government. Now, can I drag and drop the Ombudsman up to oversight? No, I can't. Can we delete that? Yes. So we've got oversight mechanisms which are part of government. They're not part of the judicial limb, and they exist to review and check on government. So there's the ombudsman systems, which comes from a Scandinavian term. And there was much discussion as to whether it was a sexist term or not at some point, and we seem to have just forgotten about that. I don't know whether the man is actually referring to a man in Swedish or Norwegian or where it comes from anyway. But an ombudsman is someone who is tasked with a responsibility of overseeing a system and reporting back on that system. They're someone who takes complaints, but they usually don't have any power to resolve complaints. Now, they might be able to refer people to correct channels. They might be able to refer them to merits review. They might be able to refer them to even mediation in some cases. But an ombudsman has no power as such to make rulings. And what they do, generally speaking, is make an annual report where they report back to whoever they report to and say, these are the things that have happened during the year. So what the most commonly known ombudsman is who's technically a Parliamentary Commissioner, who reports, and I think there's the Commonwealth level, they're called the Commonwealth Ombudsman, but their technical title is the Parliamentary Commissioner. And what they do is they hear complaints about government, and every year they table a report in Parliament and say, by the way, 4/5 of this report is all about migration this year again. Most of the rest of it is about social security, and these are the things that have been done very badly, and these are things that we found complaints were valid about in relation to. Weirdly enough, Victoria has used that approach for the Bill of Rights, and if you've studied human rights, you'll know that's a very weird approach. The rights we have in Victoria are kind of not enforceable rights, but they're things that you can complain to the Parliamentary Commissioner about, and the Parliamentary Commissioner can come back each year and say to Parliament, by the way, we've had some heinous breaches of rights again this year, and Parliament can table the report and say, okay, let's go on to the next thing. So the Ombudsman is not necessarily all that useful if you're trying to get them to do something else like protect rights, but if it's general oversight of bureaucracies, they can be quite effective because they basically talk about budget. And they say, by the way, there was a lot of messing around in Social Security this year. There was a lot of bad behaviour that caused a lot of appeals, and this cost us millions of dollars because this government department doesn't have its act together. So they're rights oriented in some ways, but they're also got a keen eye on budget. Do you know about any of any other ombudsman?
I think there's one for Telstra, isn't there? Telstra.
There's the telecommunications industry ombudsman.
What about the renters for rental and tenants?
Yeah, I think
Whenever there's quite a problem.
yeah, I'm not certain, but I think there is a rental tenants. That would be a state government thing in some states.
Is the Fair Work Ombudsman?
Yeah, I'm not. I'll put that down. I'm not speaking with any authority on employment law. I will believe you that there is one, but don't take my word for it.
I just did employment law last term. There is
fantastic, fantastic. And one you might like to know about the universities. Ombudsman, which CQU had to deal with recently when we tried to cancel some courses when students hadn't finished them. And the students went to the university's ombudsman and said, can you do that? And they said, well, they can't say no, but they can waggle their finger at you and say, we think this is really inappropriate. And we were suitably chastened and shamed by the experience. The thing that's interesting about the TIO is that it's funded by the big teleco organisations. And it's an interesting example of where, banking. It's another one that's in industry funded, the banking ombudsman. And again, this is a really interesting example of self-regulation and how it's often in the interest of the industry, because even though they don't necessarily have the best motives for doing the right things, it's in their interest to try and streamline and smoothen and to look like they're playing fair with everyone else. So banking, telecommunications industry are examples of where they're not government funded bodies. They have some recognition within law, but they work to resolve complaints. So Telco's ombudsman was very active a little while ago in the language in mobile phone contracts. When I was looking at it, this was the early 2000s, the Telstra mobile phone contracts were around 300 pages long, which no one ever got a copy of. They just sent people PDFs of. And part of the thing was they included all the products, all the different phones that they issued and had issued in the past in that contract. And the TIO felt that that was bad practice in that no consumer was ever going to read a contract of that size. And things got changed and things got shaken up. So we do have ombudsmen are not just government, they're also private. Any other oversight bodies you can think of that are relevant to what we're studying?
Is there something for immigration? There
might. I mean, there's the tribunal, which is part of the AAT system. I don't know if there's a migration ombudsman or not. I guess we could look that up and see. I'm thinking of something that's in the news at the moment. Pauline Hanson wants one. Don't say brain.
Inquiries?
Yes. That's... Okay. You can see what a mess this is looking like at the moment. Commissions of inquiry. Again, they are an administrative body and they're established by executive power, although they are enabled under legislation. So we have royal commissions and we have I'll say state commissions. They're really not all that different. It's just Royal Commissions of Commonwealth and State Commissions of Inquiry are under the state legislation. It's the Royal Commissions Act, the Commissions of Inquiry Act. And the third form of variation is standing commissions. Now, to understand these, and these are a bit of a hobby of mine since my first job was working for one, the history of the Royal Commission is in its title. It was a commission from the King, and the King would say, look, there's a really bad smell in town at the moment. We think the sewage is backing up in the moat. I give you a commission to go out and find out what's wrong and come back and tell me what's wrong. So it's like getting the royal stamp to go out and find a fact-finding mission. They have terms of reference, and those terms of reference are limited. So the King says, you can have my royal seal to go out and investigate this, but your limitations are this. You have to find out what's causing the smell. You have to do it within 14 days. You have to issue a report in such and such a way. So commissions have no power to actually change things. They're purely reporting. But part of that, and we'll look at this in depth towards the end of term, is they have very broad powers. So there's no privilege against self-incrimination at a Royal Commission or a Commission of Inquiry, at least in Australia. It's different overseas. And in America, they talk about Senate hearings or congressional hearings, same thing. So what happens then is they have these vast powers to compel people to attend. They can compel truth out of people. Like, people would still lie, but they have the power to punish for contempt. And there is no privilege against self-incrimination. The flip side of that is you can't use any information that you give to a Commission of Inquiry in a later prosecution. And there's two ways of looking at that. One is you can't use the testimony someone gave to the Royal Commission as evidence. And that's the narrow version. That's one version. It's the one we use in Australia. That basically is you can't actually go and prosecute someone and say, what proof have you got? The proof I have is the recording of this hearing where this person said this, and that's therefore proof. Question is, can you find that information through a different channel? If someone says, I've done all these terrible things, can you then go and start another investigation, find out the proof of that, and then prosecute them? In Australia, you can. In America, they actually have a protection of any fruit of the original testimony that's given, that any information that is derived from that testimony that you give is also protected and can't be prosecuted. Which is better? Well, our system is, it is very hard to prosecute someone in the American system, and people can kind of get immunity by going and going to a congressional hearing and confessing everything and then getting some sort of blanket immunity because of all these things that they say. But there is suspicion around the Australian system that it is quite easy in many cases to go and get that evidence from another source. And is that really fair, that you compel someone to give evidence and then you say, well, we're not going to use your testimony, but we're going to go and ask your friends and we'll get them to confess and then we'll use their testimony against you and so on. Anyway, that's a little bit about commissions of inquiry. Standing commissions are different in that they have ongoing terms of reference. Most commissions of inquiry are limited. Standing commissions, such as is it still called the Criminal Justice Commission in Queensland? I think it might have had a name change. Independent Commission Against Corruption. A lot of those bodies are commissions of inquiry, but they have a terms of reference that roll over each year, and they have their own legislation that empowers them. The one-offs are all empowered under either the Royal Commissions Act or the Commissions Inquiry Act of each particular state. And the sort of exemplar of this was the Fitzgerald inquiry. And the Fitzgerald inquiry was a inquiry way back at the dawn of time for many people into police corruption in Queensland. What confuses people too is that they often put judges, in Australia anyway, they put judges as the head of commissions of inquiry, and people then call them judicial inquiries, and they're not, because the judges are not acting as judges, they're acting in a governmental role. I don't know, we seem to think that judges will do better in that job. We'll talk about this more later. It is questionable as to whether we should be putting judges as heads of inquiry. The UK doesn't do it, and they manage quite well. And we often end up with inquiries that are just full of QCs or senior counsel, because everyone's terrified of the powers that the Commission has. UK, they have fewer powers. They don't have judges, but they get more things done because everyone's not looking over their shoulder. Anyway, Fitzgerald inquiry into police corruption had a very limited terms of reference, but every time they dug, they found more corruption, and they found corruption in politics, they found corruption in other sectors. So what they had to do was to go back to the Attorney General and ask for extended terms of reference. They needed longer time, and they needed more wider powers to look at different areas. So you're in the very strange situation of where you're asking Attorney General of a government to have permission to investigate that government for corruption that sitting members of Parliament were involved in. But because it was so public, the Attorney General couldn't really turn around and say, no, we're not giving you powers to look into us. And it was a really weird time, because every time they got more powers, more politicians were exposed and more corruption was exposed. And they came back and asked for more powers, and the Attorney General couldn't really say, look, no, you can't have any more power. And ultimately, it toppled the government and exposed a huge amount of corruption over a great period of time. Then, of course, all the evidence that they've gotten of some pretty nasty criminal behaviour, they couldn't prosecute any of it, because all the information had been given under the broad Commission's inquiry power. It had been compelled. There was no privileging of self-incrimination. So they had to set up a special prosecutors unit to actually prosecute the corruption. And they had to do it without the evidence that was given to the inquiry. And the media lost their mind over this, and most ordinary people could not understand the point of all of it. And look, I understand it all because admin law is what I do. But I also appreciate that it is a fairly strange situation that you can have a huge inquiry, you can have people admitting to terrible corruption in a courtroom before someone who is a judge, even though they're not working for a judge, and then say, well, we actually need to prosecute them now because none of this is legally binding. None of this we can actually prosecute them on. Anyway, so the Fitzgerald inquiry is an interesting example of that. There was also two bodies set up as, I think they were standing commissions at the time, to roll out the changes. One was the Criminal Justice Commission, which, as I said, I think it's changed its name. The other was the Electoral and Administrative Review Commission, EARC, which is what I worked for. And they were set up with a mandate to bring in an administrative law system for Queensland, which it didn't really have, to change the political boundaries, to introduce a Bill of Rights, which is what I worked on, which never happened, but, you know, it was an interesting experience. But EARC got wound up. After a few years, it actually got dissolved, whereas the CJC continues to live on in at least some form. Anyway, that's a lot of stuff on commissions of inquiry. Obviously, I could probably teach a whole course on commissions of inquiry, and you might not be all that interested in that, but I find them to be kind of fascinating. And if you look through the different ones there's been, they're on every single topic, and they're very interesting. Even in a very boring way. Of course, you can't have a commission of inquiry into Islam. I don't know who's going to explain this to Pauline, but your terms of reference have to be fixed. You can have a commission of inquiry into, you know, investigating links to terror organisations, or you could actually, it needs to be pretty specific. It can't be focused on just like a whole religion. You could actually get some information on a particular organisation, particular links, and you could investigate it. But you can't just have a commission of inquiry into something you don't like. Like, you can't have a commission of inquiry into poverty. We know poverty is a problem. We'd like to do something about it, but we can't just set up a commission of inquiry and say, go for it, go fix poverty for us, or make recommendations about poverty. All right, I realise time is getting away from us. The other thing that we probably should add as another limb to this model is the rights, system of rights. I'm just going to jump ahead through this. And we've got constitutional rights, which we used to say were limited, but they now seem to be more important than they were. We've got freedom of information rights, and we've got privacy rights. And there are probably others. In fact, you could probably make an argument that the different grounds of review under, say, the Judicial Review Act, by de facto create rights. So because you can review a decision where you denied natural justice, you could kind of argue that you have a right to natural justice, if that makes sense. Because if you've got a thing that allows you to challenge a decision on the basis of this, what you're effectively doing is de facto creating that right. So again, when we look at Section 6 of the ADJR next week, they kind of look like a list of rights. You know, you have the right to have decisions made without bias. You have a right to make decisions made based on good evidence and those sorts of things. So the right systems sort of sit alongside. And I guess the thing I wanted to start to get a sense of is that these things all work together. That they're all part of a bigger system. And they may not be brilliant at working together all the time, but they are part of an overall bigger machine with smaller working parts. I'm going to stop sharing now and jump back to see what's been happening in the chat window. If a government decision makes a decision that's against the law, can merits review still be used to rectify? Yes. And in fact, what we've found is that over time, a lot of the ideas from judicial review have colonised merits review. Back in the old days, the AAT was all social workers and retired army captains and people who said, we don't want lawyers here, we want to keep the lawyers out. We don't want this legal fidgy-widginess on review of decisions. We want, whatever. But over time, more and more lawyers got onto the AAT because the stuff they deal with is legally complicated, and a social worker may not necessarily appreciate the legal aspects of it. And what we've had is sort of this creep of ideas like natural justice have started colonising what the AAT does. So yes, the AAT can review a decision on any basis, and the fact that it was illegally made is one that they can use as well. Judicial review is usually not the first path because it's so expensive. You've got to have someone, go to, for the Commonwealth, it's to go via the federal court. You've got to retain counsel, yada, yada, yada. It's expensive. Last time I checked, and it's probably been inflated since then, filing fees were like $28 or something at the AAT, and you could represent yourself. So there's a vast difference in scale between those in terms of money. Difference between judicial review and appeal to a higher court. Judicial review is of an administrative decision, of a government decision. An appeal to a higher court is a review of a judicial decision. So judicial review, I mean, again, if you haven't done constitutional, this is not going to make as much sense. But the closest equivalent of judicial review is constitutional challenges. So, if a piece of legislation comes into play and you think it violates the Constitution, you can take a constitutional challenge and the High Court can strike down legislation that is inconsistent with the Constitution. This is kind of a small version of that, where you've got, rather than a Constitution, you've got legislation that confers power on government. And then you're checking through judicial review whether that legislation has been complied with and whether the decisions are consistent with that. And hopefully next week that will make more sense. But it is like a little constitutional challenge, except instead of the Constitution, we're looking at an empowering act that actually confers that power. And the comment from Ricky that it's a Crime and Misconduct Commission now, the CMC. So they've obviously been rebranding. I think it was something else somewhere along the line as well. Who knows why they do these things, but they seem to have a continuing life, especially in the criminal justice arena. Okay, we have a couple of minutes left for other questions. Let me just quickly check I didn't miss anything from that, that coggle. Oh, I didn't put Whistleblowers Protection down there. That was the one thing I didn't put in. And that's not consistent. Some states have Whistleblowers Protection, and that's legislation that stops people being persecuted for whistleblowing. And at EARC, we considered that to be a very important extra part of the system. Because if you could bully people into not disclosing information and not blowing the whistle on corruption, then basically you'd never have corruption inquiries because people would remain silent. There isn't an equivalent at Commonwealth level, and it's quite interesting to see the things that happen with the NBN, with people, you know, just leaking information. Where these arguments become very, very important. Now, whistleblowers legislation is not just carte blanche for leaking. You can't just decide you don't like something and you can say, "Oh, whistleblowers, I'm just leaking it." But if there's a strong public policy reason behind that, it allows people to do that, and it stops things like the Official Secrets Act being used to cover up things that are misconduct. And I know there was a particular member of Parliament who didn't want information on his cab charges being made public, and was very angry when someone released his parliamentary expenditure to the world, and believed that that was a matter of national secrecy because terrorists would know where he'd been and obviously could then plan the route, given all these long cab journeys that he'd gone from place to place. They could identify where they was. That was a very spurious attempt to use national security to stop whistleblowing on your own parliamentary expenses. And, you know, one thing I do like to, I mean, I did have someone previously complain that I talked about the Fitzgerald inquiry and how unfair it was because, you know, the poor National Party government, you know, were persecuted by the Fitzgerald inquiry. And I don't tolerate that. The facts are there. They were corrupt as hell. But I don't want to be party political in this subject. Obviously, there's lots of fuel there because of the Fitzgerald inquiry, and there's some great stuff from New South Wales, from other governments of different stripes. I am opposed to all corrupt governments. So, you know, this is not just a case of sort of bashing Conservatives or bashing particular parties. It's about accountability for all governments, and they're all pretty bad. The British parliamentary expenses scandal, where people were claiming for like duck islands and things, that was right across the board, and that was Labor and Conservatives there. That was very disgraceful as well. Okay, are you able to post the mind map to Moodle? Yes, I should be able to post the link there. Okay. Queensland needs a new inquiry big time. Problem with inquiries is they're very expensive. Having worked inside one, I'm a big fan of them, and I think where they work properly, they're great, but they're so expensive. John said the constitutional review video wouldn't load. Does anyone else have that problem? It should just be a link to a YouTube video. So, yeah, maybe it might be a YouTube problem you're having, John. I know I had a lot of trouble late last week just uploading the stuff for this week, which is why some of it's late, because I had about 4 days where things would get this close to being uploaded and YouTube just went, no, no, go back to scratch. I don't like that. So there might be something going on. And as with most cases, usually try opening it in a different browser. Go for Firefox. Yeah. Yes. So I wanted to clear that too, because I mean, obviously one particular student in the past who might have been, related to Terry Lewis or something for all I know, did and it's a minor, a very rare thing, just took umbrage that thought that admin law was just a whipping post to push a particular political view. I guess it is pushing a particular political view, which is open and transparent government and democracy. If you think that's a political view, that's the political view. But we certainly aren't shy about condemning whoever from whatever party for corruption, and of course admin law is more than just corruption. It's about incompetence. It's about bad decision making. It's about making decisions without good evidence. It's about denying people their right to a hearing. It's about all that stuff that will come in next week. Unless you prefer a dictatorship. Yeah, go Harvey Norman. We will not be giving Harvey Norman equal discussion time in this course, looking at the merits of a dictatorship. What about Thoreau? We're talking about the origins of liberal legal political thought here. Liberal as in small L liberal. Okay. If there's stuff that comes up in the news, feel free to post things in the news forum for us to all have a look at too, because it's nice to have current things to apply these ideas to. Okay, so we're running out of time. As you'll see, I haven't got the last couple of weeks of study guides done, and I'm working on those very diligently to get those up ahead. I'm thinking people aren't up to week 10. No one's up to week 10 yet, so I should be safe for a couple more days. I'm also going to put some rubrics up for the assessment to give you an idea of what's expected at the different levels. And I will also put up all the workshop questions, which I'm finalising and getting up there. So I do have a few things to do. Given that we have short midterm breaks, I've actually spent a lot of the last 2 weeks dealing with issues from last term and having consultations with students over last term, but I will also make consultation time available soon when we finally put term 1 to bed, where I'll just put a Google Doc up with the times I'm available, and you can book in if you want to have a chat and you want to talk about stuff, because I realise that part of the difficulty of these online courses is that you can't just grab me after a lecture and have a chat like you would in a normal course. And sometimes you just want to, take 10, 15 minutes and have a talk about something and clarify something, and that's perfectly fine. Generally, the way I do that is via a Google Doc with some times, and you can just get in and edit it and put your own times down. For assessment 1, is there a particular format? Nope. And in fact, coming up with a good format and communicating it clearly is a good part of the task as well. So since we're so collaborative, it can be something that people could suggest things and could put things in the forum and say, what do you think about this? And everyone could have feedback on, and I could give feedback on as well. I'm generally not a fan of giving people templates because the people just work to the templates, but definitely if someone put something up and I thought it was a mistake and it was going to lead you into trouble, I would say don't do that. But assignment 1 is pretty short. What you're really doing is just giving me a pitch of what your ideas are to get some feedback on, so that you can go and work on the second one. The design thinking model is a good place to start. And week 4, module 4, we'll be working through an example from the textbook on the migration tribunal, and using that as a way of saying, well, can we use design thinking to think around some of these problems and fixing some of these problems? And I've been down to the AAT migration division having a chat to someone about that, and got some very interesting insights back from it, which is no great effort for me because they're in the same building as us in Melbourne. So it was actually really easy to go and talk to them. So all interesting stuff. So we're about out of time. Are there any last?
Before we go, I'm having trouble accessing that Zoom link on the Moodle. It won't allow me to get into it, so I had to go into Facebook and log into Facebook to get this tonight.
Okay. Yeah, I'm guessing no one else had that trouble because everyone would have said, "I can't get in."
Just me, I think.
Yeah. Oh, we're going to have a chat if it's a continue. Like I said, maybe it's just a case of are you using Firefox?
Yes. And I'm going onto the Moodle website, and I clicked the Zoom link, and nothing happens.
Okay.
Yes, I am talking about the Zoom link.
Okay.
So can I just mention something, if that's okay?
Yeah, go for it.
I had this same issue before, and the way around it that I found is if you open Zoom separately, click join, and then when you open that link, it'll open in a new tab or a new folder. Just stop it from doing anything and then copy and paste the last 9 digits of the URL, which will be the Zoom number, and post that into the join section of your Zoom, and that takes you straight into the meeting.
What I'll also do is put, I realise it's actually, it doesn't have the text of the link there. Maybe if I put the whole URL there so you can copy and paste that might work as well. Rather than clicking the link.
You can just put the number, like the Zoom number in as well on the Moodle, and the ID number.
That might be easiest. Yeah, I'll just put the Zoom number in, and then you can log into Zoom and put the meeting number in. Yeah, I'll do that. I'll do that straight away. Good to know, because you never know sometimes when these things behave oddly. All right, folks. Well, I'm going to stop recording now.